sure.
way easier to have you
Yeah,
explain.
I can see that. Okay.
Okay, everybody rolling? Go ahead.
Do you want to start with a statement? Or?
Oh, no, just,
okay.
sure.
What was the argument for the
Well,
motion to dismiss?
the argument today is this is a statute that has very specific requirements about coercion, and it's our view that what has been charged here, even though we disagree with what the government says happened, even if it happened, we don't believe it's a crime. The issue here is not about whether they were, say that again, there is no question that our clients did not physically hurt anybody, did not threaten to physically hurt anyone. There was no physical coercion of any type. This case is kind of an interesting one because it kind of is about whether you can extend this law and call something forced labor when at most what you did was tell people what is the natural consequence of them not doing their job, which is you'll lose your job. And in this case, because the workers were only here on a work visa, they'd have to go home. So the question becomes, can that even be a crime? The court is taking it under advisement, although I think you could see from what she said, she seems to be saying that we probably need to let the facts play out at trial, and then she's in a better position to determine those things. In terms of the case itself, the last couple of years have been very difficult on Alec and Mike Sue. They're really looking forward to starting the trial because we believe that the facts are very different than one might think in reading the charging document, and they're happy that the trial is here, and we look forward to being able to have the real facts play out in the courtroom in front of the juries and in front of you guys.
Now, one of the arguments you made today, sir, was the idea that this was sort of vague and it had to be redefined. And at the time these allegations happened, help me understand the difference between the law in 0405 and the way it reads today and how that was argued in court.
Well, the issue is the law in 04 and 05 said that it would be wrong to compel someone to work based on serious harm or physical restraint. That's it. It didn't say anything else. Our view is that when you read that, one would think it means injury, hurting someone, which of course is not an issue in our case at all. Since then, in 2008, Congress has put a definition that says serious harm can extend to financial things. And so our point is, one, that doesn't apply to 2004 and 5 because it wasn't there. But two, what is serious harm? In this day and age in particular, all of us would be seriously harmed if we lose our job. If I lost my job, I'd be seriously harmed. If the definition is, are you in financial trouble? Our thought is it has to be more than that for someone to have committed a crime.
What are the challenges going to be in terms of picking a jury? This has been such a high-profile case, and this is also an interesting case in that at one point the Sioux had pleaded guilty to it and then withdrew their guilty pleas. I mean, what are the challenges there in terms of obtaining a jury that can see this case and, I guess, evaluate the evidence and not be swayed by any things that happened prior?
Yeah, Mr. Otake and I don't believe there are challenges. We think it's just getting 12 fair local Hawaiian jurors to hear the evidence objectively, and that's all we can ask for. And frankly, the beauty of our system is we have all this legal wrangling, and we all do our legal job, and the judge sits over the case and tells us, in her view, what the law is and the rules of the road are. But ultimately, it comes down to 12 local Hawaiian citizens who decide what did or didn't happen, and we're comfortable with that.
She was inclined to dismiss the motion. Your thoughts about not necessarily winning today?
Well, she was inclined to deny the motion.
Deny the motion.
Well, she's been very good and very patient in taking careful thought to our motions. I think sometimes a judge wants to hear more facts before they can make these decisions, and if that's what Judge Mulway decides, we're fine with that.
Can you elaborate, I'm just real quick, elaborate on the number of charges that they're facing, because I knew that under the original plea agreement some were thrown out, but that's all back in, and then there was a new indictment. Can you just kind of lay out what it is that they're charged with and how many counts?
Well, the indictment really has sort of three sections. One is the alleged wrongdoing, which we say wasn't wrong or didn't happen, with the Thai workers and what happened when they were working here. The second part has to do with after they all left and whether or not some workers were here when they shouldn't have been. It's sort of the opposite of the first charge. And then the third part has to do with whether or not a video played in front of Judge Mulway was somehow obstructionist, and of course we deny that categorically. We believe that there was nothing wrong at all with the evidence presented to the judge.
So the number of counts across the three?
I don't remember. I think it's around 12 counts, but those are the kind of three categories. All right?
Thank you, sir.
Thanks.
Okay. Bye, guys.
Thanks, Mr. Bienert.